Striking workers in the steel sector have hit a brick wall. The Labour Court has ordered workers at ArcelorMittal's steel plants, blast furnaces and coke batteries not to take part in an ongoing strike. The National Union of Metal Workers of South Africa began a strike at the company on Wednesday after wage negotiations broke down last week. ArcelorMittal approached the court to seek the exclusion of certain essential workers from the strike, citing South African labour law. The union is demanding a 10% pay increase, a housing allowance and payment of 80% of medical insurance costs against the company's final offer of a 7% salary increase. Now, it's unclear how many union members will be affected by this order. We can speak now to spokesperson for Numsa, Phakamile Hlubi-Majola. Phakamile, good to have you on Daytime Update. First things first, have all your members who are covered under this order returned to work today? Phakamile, I believe you are muted. Let's see if we're able to hear each other now.
Sorry about that. Can you hear me now?
Yeah, we can hear you now. We are just asking how many of your members have all your members, in fact, who are covered under this order, gone back to work today?
As I was saying, good afternoon to you, Tembegile, and good afternoon to your viewers, and thank you for having me on the show. We only received the order late yesterday afternoon, and communication to members was sent out last night. We've been consulting with members since this morning on communicating this decision by the Labour Court, which effectively has interdicted those workers who are in coke batteries, the steel plant and in the blast furnaces from continuing their participation in the strike. At this stage, I can't really confirm who has returned or if they've returned, because this was a strike, and a lot of our members who are affected by this, some of them are not even in the province, but we are doing the best that we can to get the message out and to consult to members regarding this court decision. So
am I right to say that you will not fight it further, the return that is of these quote-unquote essential workers?
Well, remember that this is a temporary interdict, and the basis upon which this interdict was served was on the basis that ArcelorMittal believes that because this matter of declaring this particular division within its operations essential service, or what they referred to it rather as maintenance services, that process is underway. It's before the CCMA Essential Services Committee, and it has not been concluded. So they went to court and said that, look, we think there's a reasonable prospect that we would be successful in this application, so we would like the court to interdict these workers from participating in the strike. The court said they would implement this temporary order. They've not made judgment on whether they agree with ArcelorMittal. It's just a temporary order pending a judgment. So that does not mean that the strike is over. It does not mean that the demands are any less relevant or important. We are actually waiting for the judge to give us a decision. But in the meantime, while the judge makes his or her decision, these workers would have to return to work.
So in order for a strike to be fully effective and put pressure on an employer, it's meant to have a serious impact, right, on the employer's ability to operate. Now that you've got these workers who have to go back to work, even if it's on an interim basis, how many are covered under that, and how much of an impact do you think it'll have as far as piling pressure on ArcelorMittal to then either come back to the negotiation table or indeed give in to your demands?
I think it's important that your viewers must know that first and foremost, we view this tactic by ArcelorMittal to make this application to the court on this basis as very mischievous and as a reflection of their anti-union attitude. And it's also a reflection of the fact that they don't really support the right to strike, in our view. The very fact that they're even making this frivolous application, and we view it as a frivolous application before the Essential Services Committee to deem some aspects of their business as essential service, is nothing more than an attempt to violate the right to strike or to undermine the right to strike. And I think you have to view this from the perspective of an employer that is hostile to workers exercising their constitutional right to strike. Instead of coming to the table, and mind you, they had lots of opportunity from the time that we were issued with the strike certificate up until we actually went on strike to engage us meaningfully or to call us to the table. In fact, the day before the strike, we met to discuss picketing rules. Even at that point, they had an opportunity to call us around the table and engage us meaningfully. So as far as we're concerned, this is nothing more than an attempt by this employer to basically blow the confidence of workers, undermine the confidence of workers as they go on strike, to undermine the right to strike, instead of actually just coming to the table and engaging meaningfully and finding a middle ground so that we don't even have to go on strike.
So how effective then would you say the employer has been in basically ending the strike through a court process, even if it's not an official declaration saying stop the strike altogether?
Well, you can say that they've been effective in the sense that they've obviously managed to secure an interim order which blocks those three aspects of the business from being able to participate in the strike. But is that really an ideal situation? I would think not. I would think that an organization which made obscene profits of more than $14 billion last year would want to have an attitude where they'd want to give back to workers and would want to actually engage in a way to negotiate with workers and demonstrate that they actually care about those workers, that help them to exceed their profits more than they've ever exceeded them since 2008. But what we're seeing instead is a lot of hostility and a lot of greed, quite frankly, on the side of ArcelorMittal management.
Final one then, ArcelorMittal, in the last bit of reporting that I saw about the wage discussions, was that the company feels that its 7% wage increase offer is fair because that is compared to an industry average of around 5.5%. As things stand, why is 7% not an acceptable or workable offer for Numsa?
First of all, the company is not being honest when they say they're offering 7%. They're not. They're offering 5% across the board. And then they're offering a 2% cash payout based on your wages. So only 5% of what they're offering is across the board. And that 2% is not an across-the-board increase. It's just a cash payout. It does not extend to benefits. It does not extend to provident fund and medical aid and all of those other benefits that come with an across-the-board, a genuine across-the-board increase. So effectively what they're offering workers is a 5% increase. We are demanding a 10% increase. We've compromised. We've moved from 15%. We're now at 10%. We think the company can and should afford it in good faith. I mean, they themselves, in their own propaganda that they released last year, confirmed that they've made more profits than they have since 2008. In South Africa, they made 32 million rand during a time of a deadly pandemic. And it's quite disgraceful that even though they made those profits, and they managed to do that because of the hard work and sacrifices of their members and of workers, they're now being greedy and refusing to give back.